Dear friends, in the last chapter, I had covered the classification of workmen, that how many class of workmen are and what precautions you should take, how you should engage them. If you wrongly engage them and you just keep on employing, the day after some years, they will call themselves permanent, and to discharge or to terminate their services will be a big problem and a lengthy procedure. Today I will take up in that context in second chapter about the departmental and domestic inquiries, because once you become, how it will lengthy, what procedure you will adopt, why I am saying to terminating a permanent workman will be difficult. Now this all departmental inquiry will reveal the facts and make your concept clear. If a person becomes permanent in any organization means any industry. Industry means maybe a shop and commercial establishment, maybe a factory wherever you employ people, maybe any commercial establishments, all are industry. Once he is a permanent and you want to discharge him, you want to terminate him, not discharge him, you want to terminate him. Termination means why you will terminate. Maybe you are terminating his services because he has done some mischief, some misconduct. Misconduct may be of many times. Maybe he tried to misbehave with superiors. Maybe he is guilty of some theft. Maybe he is indisciplined. Maybe late coming, maybe anything. Misconduct is also defined in standing orders. What kind of misconduct? Even moral turpitude is also a misconduct. So all have been defined in the standing orders which I told you. What is the procedure? Procedure is, first, you find a person, an employee, a workman I am talking about, is guilty of misbehavior with his superior. What you will do? You will give him a charge sheet. What is charge sheet? You put all the charges, you frame all the charges, incident narrating charges, and then you give him some time to reply. If it is urgent, maybe 48 hours, maybe 24 hours, or maybe 7 days. But normally it is 48 hours. You ask the workman to reply to that charges which has been imposed upon him, and then he replies to that. Framing of charge sheet is a very lengthy chapter. At the moment I will cover the basic, what is A to Z, what is domestic inquiry. Then probably again in third chapter I can elaborately cover each part of the domestic inquiry. Like you talk about a total man, or you talk about what hand does, what eye does, what mouth does, what legs does, then elaborately that can also be discussed, because every part is very important. So I am at the moment telling you what is a domestic inquiry, how it is conducted, and what are the basic things. So one is a charge sheet. You frame charge sheet for the incident and you give to the workman. You can also suspend him before or after or with charge sheet, both. Suppose circumstances are such that you find if that man comes in a company that will put more damage to the organization, you can immediately suspend him, followed by a charge sheet. You can in charge sheet itself cover a suspension, that with this, along with this, you are charged, you are suspended, and reply within 48 hours or 7 days or whatever it is. Or you can say you reply, and then when you don't find, you can suspend him during the pendency of the inquiry. So suspension is in your hands. It may be before, it may be simultaneous, it may be afterwards. Charge sheet framing is a different part, which it's a very technical, because if charge sheet is not well drafted, that may not hold good in the court of law, at the labor court. So we will discuss charge sheet later on. After charge sheet, he replies within the stipulated time. After that reply, you find whether you are satisfied, then you let the man go. If you are not satisfied, then you may give him a warning, or you may say, the third thing you can do, you may say that, well, we are not satisfied with your reply, with your answers, and the inquiry will be conducted against the charges imposed upon you by such and such inquiry officer. And then you give an engagement letter to an inquiry officer who will conduct the inquiry according to the principles of natural justice. The whole inquiry process depends upon the principles of natural justice. What are the principles of natural justice? I will just throw light for a minute. Any action, by doing it or by not doing it, if it is causes prejudice, that means it is unfair. It is not following the principles of natural justice. For example, a witness has not been given a chance, workman witness, to be cross-examined. You don't give a chance to workman representative or workman to cross-examine the management witness. This is an action which is causing prejudice. So this is illegal and not following the principles of natural justice. So simple formula, by doing it or even by not doing it, if it causes prejudice, then it is unfair and not following the principles of natural justice. So the inquiry does not follow the strict rules of Civil Procedure Code. You may parallel go on, but it is not following that. So what it follows? Principles of natural justice. Charge sheet, suspension, reply, appointment of inquiry officer, then conducting an inquiry independent by the inquiry officer. There may be many points. Who can be the inquiry officer? Suppose you appoint your own officer as an inquiry officer. Is it wrong because he is your management employee? Yes, you can do it. Because in many departments, this is a departmental inquiry. So the department head can always be appointed as an inquiry officer. It can't be said like in BHEL, they always appoint the departmental people because they are the technical people. They know the technicalities. Normal man will not know it. What are their technicalities? So he can't do the inquiries. Some technically fault is there. He will understand. So the departmental people can also be appointed, and it cannot be said that they are causing a prejudice. In most of the technical organizations, departmental people conduct the inquiry. So charge sheet, reply, suspension, then inquiry procedure is very simple. You make a inquiry officer, one representative is management representative who will put the management case, and the workman can also bring his representative and then he will represent his case. The management will bring his witnesses and that will be cross-examined by the workman or his representative. The workman will bring his witnesses and that will be cross-examined by management representative, so that then that all is recorded. Everybody puts a signature on the proceedings, so that the proceedings they can't deny tomorrow that we were not the part or something was not done, and everybody puts a signature, whoever is present. There are certain principles that if one workman is producing one witness, another witness should not be there, otherwise he will reproduce the same witness. These are otherwise so many points are there which I may cover separately. Similarly, if management is producing one witness, other witness should not be in the same room because he will reproduce the same thing. What is the principles of inquiry? Suppose there is a confliction in the same incident, that means there is a lie, because you can't put two conflictory statements for the same incident. Therefore, if the witness is there, he will produce the same statement. He should not be there. If he is there, second witness is also in the same room, you are violating the principles of natural justice. I'm getting my point. So this is the way you conduct the inquiry. Now there is one more point. Sometime the advocate they bring. Suppose the management brings his advocate as a representative officer, then the opposite party should not be allowed to bring his advocate if he wants it, because this is no question of a third person outsider. This is only your internal matter. So management representative and a workman representative is sufficient. If a workman is bringing an advocate, it depends on an inquiry officer whether he is allowing him or not. If he wants, there are judgments on this point which I can produce, because this is the initial program to enlighten the people, to help them. This is no professional lecture which I am giving here. I don't want to go to the complicacies and the judgments and all that, but this is established principle. If you workman wants to bring an advocate, he can bring it if the enquiry officer allows, and this is totally discretion. And if he brings it, that will be but then a management repository is also allowed to bring the advocate, because there should be a balance. So then later on the enquiry report is submitted. Enquiry report is submitted to the management. One thing very important, sometime enquiry officer writes in the report that this punishment should be given. He is not supposed to write this. He is only supposed to write that the charges are whether proved or not proved. He can't write that what punishment. He can't advise the management, or he can't suggest the punishment. So it is his duty only to see that the charges have been imposed. Out of 10 charges, 10 have been proved, or the 5 have been proved, or 3 have been proved. He is found guilty of the charges number 1, 2, 3, or all 10, or one charge is there, the charges. So that what and then the discretion is in the hands of the management. If the management wants, this is also very important, management wants to take action of dismissal, discharge, penal punishment of holding an increment, this all is in the hands of the management. But suppose the workman has been found guilty and management doesn't want to hold him, take action, they can do it. And suppose the other condition, he has not been found guilty and the management feel he know he is guilty, so can he do it? Yes. Management can defer the decision from the report of the enquiry officer. But then the judgments are, he must write, if they are differing from the report of the enquiry officer, then they must express and write in detail what reason, on what basis they are differing from the decision of the report of the enquiry officer. Now dear friends, I would like to conclude the chapter 1 and chapter 2, because both are interrelated. So that is why I had taken up the classification, and in second chapter, as I told you in the first chapter, that if you are permanent, because what happens in any new organization, that you keep on taking people without saying under what head you keep it, and one day you find some misbehavior is there, some misconduct is there, you have to dismiss them, you have to terminate their services. You run to a lawyer and he says he has become permanent, then you give him a charge sheet, and this is department. So once you know the departmental inquiry and termination of the permanent workman, you will be careful, because in temporary you don't have to do all these things. In casual you don't have to do administrative procedure. In ad hoc you don't have to. Ad hoc means only again the temporary for some time. You don't have to do. In substitute you don't have to do. So you have to do strict administrative procedure only in permanent. So one should always be careful, and now you will be careful that the people should be avoided to be a permanent until they are worthy and they have performed very, very well. Then you will allow and you will take all these precautions. And once they become permanent, then this is a very lengthy procedure. This only doesn't finish up the enquiry report. Then this is also challenge, in fact. Then it goes to the labor court and then travels up and up and up. So you know now and conclude that your concept is absolutely clear how to, when you keep an industry, start an industry, how you should keep employee, under what head you should keep an employee, and what precaution you should take up, so that you are away from the problems. You can't absolutely stop anything, but you can avoid the things. You can be better footed, and I think you will be enlightened this, and you will like to. This is only this I am talking not for lawyers or for very high technically qualified people like lawyers like me. This is only for the beginners. You require this information, we don't know, and then you commit mistakes, because the big employers always go to big lawyers, they get the support. Where you get it, where you get this knowledge. So this is only purpose, and I think I have fulfilled it. Thank you very much.